We talk about the Constitution a lot, as I do. One of the problems you have as a speaker is that it's a pretty serious subject and it's hard to find any jokes about it. But I did not know about the Minnesota Constitution, and that's going to be my joke in the future. So this has been a really great trip. Well, I write about Abraham Lincoln, but the real hero of my books is the United States Constitution. And one of the reasons for that is that in the Lincoln field, the standard work on the Constitution and Abraham Lincoln is it's a wonderful book by James G. Randall called Constitutional Problems Under Lincoln. It was published in 1926, and yet it still is an indispensable work that you have to use. But it has left us with one unfortunate legacy, and that's because of its title, Constitutional Problems Under Lincoln. It has left us with the idea that in the Civil War, the United States Constitution was a problem. Well, it wasn't, or at least not in my view. On the whole, it was an asset to the Lincoln administration. It shaped the Civil War. It helped the Union war effort, and I'd argue that it accounts in very substantial part for the Union victory in the Civil War. And let me explain briefly how. I think it's very important. I want to make this point initially, that I think the Constitution was essentially an asset before we talk about some of the problems under the Constitution. So how did it shape the Civil War? It's very simple. In the article dealing with the executive, the second article, of course, the President of the United States is given in Article 2, Section 1, is given a 4-year term. And then in Article 2, Section 2, is made the Commander-in-Chief. And in some ways, that's the story of the Civil War. Because that meant, since the Civil War began, is coincident with a presidential term, almost exactly, that meant that for 4 long years, there was going to be a determined anti-slavery Republican who would fight the Confederacy until he was no longer president. Nothing short of impeachment or assassination was going to stop Abraham Lincoln from fighting the war with all of the resources that he could muster. Well, impeachment was out of the question because the Republicans controlled Congress. And, of course, the assassins didn't get to Lincoln until after 4 years. So the certainty of his 4-year term meant that Abraham Lincoln, as Commander-in-Chief, really did not have to worry that much about public opinion, and certainly didn't have to worry about it in the short run when there was a temporary setback on the battlefield. And that was very important because the Union suffered many temporary setbacks. And so to appreciate the significance, just think of what the United States during the Civil War would have been like if we'd had, instead of the Constitution, a parliamentary form of government. If we'd had a parliamentary form of government, the Lincoln administration would have been in office for 5 months, not 4 years, because of the astonishing defeat of the Union Army at the Battle of Bull Run in July 1861. We have trouble thinking about what a national trauma the defeat at Bull Run induced in the North, because, you know, it was quickly made to seem like a small military event by the much greater battles of the Civil War. But when it occurred, it didn't seem like a small event. In fact, it was shocking. The shock was extremely vivid, and the whole world knew about it. The Union armies fled the battlefield in pell-mell defeat. They were led by their officers. The only people trying to restrain the defeat were journalists and politicians who'd gone out to watch the battle. And one of the worst things in terms of inducing national trauma was that it was a world spectacle of humiliation. It so happened that the man who invented the occupation of war correspondent, the world's first war correspondent, was there on the scene. His name was William Howard Russell. He worked for the London Times. He had covered the Indian Mutiny. He had covered the Crimea. And he came to the United States to cover the Civil War. He was in Washington at the time of the Battle of Bull Run, but he got up late on the day of the battle. And when he went to rent a horse, well, all the other people in Washington who'd gone out to see the spectacle had already rented all the horses. And he had trouble getting transportation to the field. And when he finally got to the field, well, all he saw was the defeat. All he saw was the Union armies running toward him. And so that humiliating impression of defeat is what he communicated to the world. And it was indeed humiliating. The armies retreated essentially all the way to Washington. They arrived in a torrential downpour, so the soldiers were soaked and forlorn and humiliated. And probably no parliamentary government was going to survive that. And certainly, if the Lincoln administration somehow rode out the defeat of the Battle of Bull Run, it would have been gone in a year's time in July 1862, when the great army, the greatest army ever organized on the North American continent, the George McClellan's Army of the Potomac, and the Peninsula Campaign got close enough to Richmond, to hear the church bells from their lines, but then couldn't take it and fell back in defeat. And at that point, for sure, the Lincoln administration would have fallen after a 17-month term. But it's the United States Constitution that prevented that from happening, because we don't have a parliamentary government. And the Constitution shaped the war in just astonishing ways. I think, for example, military historians or armchair military historians have wondered for generations why it was that the Confederacy threw away its single greatest military advantage, which was being on the defensive. Jefferson Davis, the president of the Confederacy, he knew the Constitution of the United States just as well as Abraham Lincoln did. He knew that a determined anti-slavery Republican would be commander-in-chief until March of 1865. Jefferson Davis couldn't turn around and sort of say to the people in the Confederacy, well, look, just hunker down. There'll be a lot of bombardment and invasion, but if we just hold on for 4 years until March of 1865, maybe another administration will come in and we can negotiate with them and get a peace. You can't do that in any kind of government based on public opinion. And Jefferson Davis knew he couldn't do that, and he didn't do it. So instead, he had to do something. And what he did was invade the North with the disastrous consequences of the defeat at Antietam in Maryland in 1862 and the defeat at Gettysburg in Pennsylvania in 1863. So to me, the real hero of the Civil War is the Constitution. And that would be the first point I'd always want to make about it. But still, it's not a hero in all respects. Certainly, it was not the hero of emancipation. It was a big problem for emancipation. And likewise, there are great questions about civil liberties during the Civil War. But for the military outcome of the war, I think it was almost decisive. Well, I'm here today to talk about civil liberties in the Civil War mainly. And so I thought what would be best to do is just to move immediately to perhaps the most controversial arrest of a civilian by military authorities in the North during the Civil War. This is in May of 1863. And after that arrest, then the letter that Abraham Lincoln wrote to explain it, the public letter, the Corning letter. Now that's in your handout. Long excerpts from the Corning letter are in there. It's called Lincoln's Response, I think. And I'll give you some background on this letter. It's called the Corning Letter because Lincoln was answering a protest of Clement Vallandingham's arrest. There were all kinds of protests all across the North because of this arrest of this Ohio politician named Clement Vallandingham in May of 1863. And the protest meeting in Albany, New York, sent a letter to the president. And the first person to sign it, a lot of people signed it, but the first person to sign it was Erastus Corning. So Lincoln's answer to the letter is called the Corning Letter, all right? And the events that led up to Lincoln's defense of his internal security policy during the Civil War were these. In April of 1863, General Ambrose Burnside had wisely been more or less exiled from actually fighting the Confederate armies after his disastrous defeat at the Battle of Fredericksburg in December 1862. And so they reassigned Burnside to what was called the Department of the Ohio. This was not a wise choice. He had his headquarters in Cincinnati, and he had control of all the military affairs in what we would call the states of the old Northwest. As it turned out, General Burnside's approach to the home front was exactly like his approach to the Confederate Army. Frontal assault. All right? So as soon as he got in Cincinnati, he issued in April what was called General Orders Number 38. And it stated, among other things, that, I think this quote is in your handout, that the habit of declaring sympathies with the enemy will no longer be tolerated in this department. Well, Clement Vallandingham, this Democratic politician from Ohio, he was out of a job. He'd been gerrymandered out of his seat. And he took a look at this and he said, oh boy. He thought, go out and give a speech criticizing the administration. Burnside, whom Vallandingham considered a blockhead, would say that this speech was, quote, declaring sympathies with the enemy, have Vallandingham arrested. He would become a political martyr to liberty. The Democrats in Ohio would nominate him for governor, and he would win in 1863. It almost worked. Vallandingham gave the speech in Mount Vernon, Ohio in May 1863. Burnside had in the audience his spies who were taking notes on the speech. They reported it to the general. He had Vallandingham arrested. He was tried by a military commission, we all know what those are, and convicted, and then banished to the Confederacy. Well, the Confederates had no more use for Vallandingham than the Union did. So eventually he departed the Confederacy. He ran the blockade. He went to Canada and eventually to Windsor. And from there, meanwhile, the Democrats in Ohio nominated him for governor, as he had planned, and he ran his campaign in exile from Canada. Well, he lost in the fall, but they didn't know that was going to happen in the summer. And so this had caused the protests and caused the letter from Erastus Corning and then Lincoln's answer to it, the Corning letter. Now, in this letter, as I say, there are long excerpts from it in your handout there. Lincoln did 4 things. And in general, one of them we've noticed, and the other 3, which are equally important, have sort of escaped our notice. And the first thing that Lincoln did that we're bound to recognize is he offered a soundbite. All right? And it's quoted in the handout, and Lincoln said, it was often quoted at the time, it's often been quoted since. Lincoln said, "Must I shoot the simple-minded soldier boy who deserts and not touch a hair on the head of the wily agitator who induces him to desert?" Right? So that's a soundbite and memorable. The other things he said, though, you wouldn't want to forget. One of the things he did was to describe the Civil War, secession, as a conspiracy, a 30-year conspiracy. In other words, saying that the Confederacy had 3 decades of preparation, and so that in his mind, the war began, as he said, on very unequal terms. In other words, the Confederacy had all the advantages because they'd been conspiring for a generation to secede and cause the Civil War. So he created a conspiracy theory. Then Lincoln said that part of that long preparation that the South had done included the hope, and I quote, to keep on foot amongst us a most efficient corps of spies, informers, suppliers, and aiders and abettors of their cause, unquote. So in other words, they left planted in the North spies and saboteurs. And these people, he said, would operate, quote, under cover of liberty of speech, liberty of the press, and habeas corpus. Quote. So in other words, the protests of the president's policy in the name of freedom of speech, they were, and this is a quote from the letter, part of the enemy's program. So if you protested in the name of the First Amendment, you were part of the enemy's program. All right. Then, the next thing he did, which I think is even more astonishing, Lincoln criminalized silence. He said that silence was not good enough as a proof of loyalty, and quote, the man, the man who stands by and says nothing when the peril of his government is discussed cannot be misunderstood. If not hindered, he is sure to help the enemy. So Lincoln demanded a kind of noisy patriotism. Silence wouldn't do. And added much more if he talks ambiguously, talks for his country with buts and ifs and ands. Well, think about that. Who talks about his country with buts and ifs and ands? The loyal opposition does. The other party does. In the Civil War, the Democratic Party did. So in other words, the Democratic Party said, oh yeah, we support the administration unless, but not if they change the purpose of the war from saving the Union to what the Democrats regarded as a fanatical abolitionist program. The Democrats said they would continue to support the administration in the war effort if the administration adhered to the Constitution. All right? So it's the opposition that speaks with buts and ifs and ands. So in other words, Lincoln has criminalized silence and furthermore threatened the very existence of an opposition political party. Well, these are all words, part of the enemy's program, and pretty strong words. And I think that if you read the Corning letter with historical imagination, if you look at those excerpts that are in your handout, that it's the kind of letter that ought to make the little hairs stand up on the back of your neck. It is the scariest letter on civil liberties ever written by an American president, period. And you can draw a straight line from that letter to, let's say, to President Bush's Attorney General, John Ashcroft. On December 6, 2001, this is less than two months after the 9/11 attack, Attorney General Ashcroft, in a statement to the Senate Committee on the Judiciary, said, quote, "To those who scare peace-loving people with phantoms of lost liberty, my message is this: your tactics only aid terrorists, for they erode our national unity and diminish our resolve. They give ammunition to America's enemies," unquote. Is that shocking? Well, not if you read the Corning letter. So, as I said, though, these are words. not deeds. And so one thing we want to do is to measure the internal security programs of presidential administrations by behavior, not by what they say. I learned my political science actually from Richard Nixon's Attorney General, John Mitchell, who at one point said, watch what we do, not what we say. Now, I'm always careful to do that. I watch what they do and not what they say. But even if we look at what the Lincoln administration did, we can still draw parallels to the present, even in the case of the most controversial sort of behavior, torture. Were there foreshadowings of waterboarding in the Lincoln administration? The answer is yes. Among the arrests of civilians made by military authorities in the North were people who were suspected of desertion. And some of them turned out actually not to be deserters. But they had to interrogate them in prison to find out whether they were deserters or not. And one of the standard practices was to subject the suspected deserters to something that was a good deal short of waterboarding, but it did involve water. It had very painful consequences, and it was papered over by the administration with euphemisms. These things were called shower baths by the military authorities who administered them. And the practice would never have been discovered at all had it not been the case that some of the civilians arrested who were subjected to this torture, some of them were British subjects. And this resembles a little bit the early situation with the Guantanamo detainees. At first, there was more interest in the ones who were British citizens than the ones who weren't. And the same was true in the Civil War. The British government took a very dim view of another government abusing its citizens, and they watched out for it. Many of the British subjects in the Civil War military prisons were recent immigrants to the United States, especially from Ireland. The British officials listened if these prisoners complained. They, in fact, even toured the northern military prisons to see if there were British subjects in there who were being abused. And so when a British official encountered one of these prisoners who complained, well, then they would demand an explanation from the State Department. The State Department was compelled to answer. They couldn't just stonewall because of the diplomatic situation of the United States in the Civil War. The principal job of the United States Secretary of State during the Civil War was to keep Great Britain out of the war, to keep them from intervening and helping the Confederacy so it would restore the flow of cotton to the cotton mills in Lancashire. And so when the British representative complained, William H. Seward had to answer. And so that's how we know about it. Well, let me give you some examples of this. One of the British prisoners was a man named Matthew Murphy. He was an Irish-American who was put in jail in Alexandria, Virginia in October 1864. And he'd been arrested, as many of these men had, on suspicion of desertion because he was wearing some government-issue clothing. And because, in his case, he was a hard-looking man, the authorities said. And once Murphy was in prison, he complained that he had been handcuffed and suspended from the ceiling by his wrists. Federal authorities in Alexandria could not categorically deny that they couldn't say for sure that they hadn't treated him that way. Well, another British subject, J.W. Nash, represented what I think is a more typical case. Like many of these suspects who were arrested on suspicion of desertion, he was picked up in a railroad station. The government had agents who hung around the railroad stations looking for people boarding trains who looked like deserters. One of the signs was to be wearing some kind of government issue uniform part, as J.W. Nash was. Furthermore, he was with to men who turned out to be deserters, and he was carrying a substantial amount of money, the same amount of money each of the other fellows with him was carrying. So he was suspected of being what in the Civil War they called a bounty jumper. Late in the war, the governments offered very large bounties for volunteering, and there were people who took the bounties, enlisted, and then just took the money and deserted. Right? And so there's much suspicion and hatred of these bounty jumpers. He was suspected of it, put in prison, and the British minister to the United States, Lord Lyons, heard about it, and when he did, he learned that Nash had been the victim of, quote, violent cold water shower baths, unquote. The Central Guardhouse where Nash was being held, the head of it explained the punishment this way. He had been subjected to what is called a shower bath, which consists of a stream of water from a small rubber hose. It is not severe, nor at this season of the year very unpleasant, as the prisoners there shower each other for their own comfort daily. Right. The captain's description did not sound very convincing to Lord Lyons, and he told the Secretary of State, this explanation does not show that the cold water was applied in Nash's case in conformity with any law or regulations as a punishment for a known and proved offense. On the contrary, it tends to confirm the statement that it is used in the Central Guardhouse for the purpose of extorting by the infliction of bodily pain confessions from persons suspected of being deserters. Well, later that same summer, the British protested the treatment of another prisoner who had been subjected to a, quote, a hose of water directed with full and powerful action against his naked person. And that inquiry led to an admission by the highest ranking lawyer in the Army, the Judge Advocate General, that this treatment had been prescribed for certain kinds of prisoners, but it was still called a shower bath. One of the prisoners, writing to the British representative to protect him, his name was James Buckley, said that he had been subjected to showering for 2 hours until his skin broke. Well, how far up the administration did knowledge of this practice go? Well, we know it went at least as high as the Secretary of State, William H. Seward. He was forced to answer the British protests, and he did so dutifully. He asked the prison authorities what they were doing. He forwarded to the British representative their answers. But he didn't, as far as I know, he didn't participate in any kind of cover-up. He answered the British questions. But on the other hand, he didn't apparently forward reports of this to the Secretary of War or to the President of the United States. He didn't protest in behalf of the British civilians who were held and tortured. He didn't denounce the torture. He didn't attempt to end it. He just answered the British representative. Well, I think there's one other thing we need as a sort of preliminary to measuring and evaluating the civil liberties in the North during the Civil War, and that is to, I think, dismiss some of the myths that surround the writ of habeas corpus, described in your handout there in a very good definition of it, but also described as the great writ of liberty. And of course, these contests between the president and the courts when they issue a writ of habeas corpus, an order from a judge to the authorities holding someone who's been arrested to produce that body in his court and explain under what charges and suspicions he's been arrested. And if the judge thinks they are inadequate or unlawful, he will dismiss the prisoner. That's what a writ of habeas corpus does. And so we tend to think, I think, that in a contest between the judiciary and the president, that it's basically between the executive branch and the judiciary, that it's basically an unequal contest. The executive has all the power and the judiciary doesn't have much. But this simply isn't true in the Civil War. The Supreme Court at the time was undergoing a revival, in fact, maybe the establishment of the first great period of judicial activism. And it went from the Supreme Court to all the other courts, federal and state, in the land. And of course, the great symbol of this rise of judicial activism in the Supreme Court was the Dred Scott decision of 1857. And in the bookstore here at the Historical Society, I noticed they have a copy of Don Fehrenbacher's great book on the Dred Scott case. I recommend it as I think it's the best book ever written on a single case, a single Supreme Court case in American history. And what Don Fehrenbacher says in there, that essentially the Taney Court, Roger B. Taney wrote the opinion. He was the Chief Justice, and he would be the Chief Justice during the Civil War as well until 1864. That essentially the Supreme Court hijacked the Constitution for the sake of slavery, for racism, and for the Southern slaveholders' agenda. The surge in judicial activism spread to the other judges, federal and state, in the country. Now, you won't notice this surge in judicial activism in the Civil War itself, even though Roger B. Taney remains the Chief Justice of the Supreme Court. And there are really two reasons for that. The first one is simply how long it took for a case to get to the Supreme Court on appeal. And the best example of that is the Dred Scott case itself. From the time when Dred Scott filed his first appeal to his first case in the court in St. Louis in 1846 until the time that Roger B. Taney read his opinion out loud in 1857 in Washington, that's 11 long years from the beginning of it to the end. Well, 11 years is almost the time for 3 civil wars to begin and end. And so the biggest protection from judicial activism on the part of the Supreme Court during the Civil War was simply this long lag between initiation and actually reaching an opinion of the court. But I don't want you to think that the substantial silence of the United States Supreme Court during the Civil War stemmed from judicial restraint. It did not. Roger B. Taney and other justices were simply dying to attack the administration's war effort. In fact, Taney had, his biographer Carl Brent Swisher discovered this, I think. Taney had, sitting in his desk, ready to go as soon as the proper kind of case came before him, an 8-page opinion declaring the Legal Tender Act unconstitutional. That was basically the way the war was funded. And he had, sitting in his desk, ready to go, a 22-page opinion already written out saying that conscription was unconstitutional. In other words, the principal law that helped mobilize the manpower in the North for the war. Taney's mind was made up. He just needed a case to get before him in the court. They have only appellate jurisdiction in most kinds of cases. And think about this. This is the way the war was funded. This is the way the manpower was mobilized. So this would be just attacking the war itself and declaring it as unconstitutional. Well, I said, incidentally, that Taney was dying to attack the war effort, and that, incidentally, was an appropriate choice of words, and that's the other reason that the U.S. Supreme Court didn't interfere more than it did. Taney was 87 years old. He'd been appointed a whole generation ago by President Andrew Jackson, and he was ill for much of the time and couldn't attend court, and then finally died in 1864. I'll have to say, much to the relief of the Republicans. Back when James Buchanan had been president before Lincoln's election, the Democrat Buchanan, the Republicans were afraid that Tawney might die then, and that the Democratic president then would get to choose the next Chief Justice, and it didn't happen. Tawney lived on. So when the Republicans gained the presidency in 1860, well, it looked different. And the Republican senator from Ohio, Benjamin Wade, wrote in 1863, while Tawney was still alive, quote, "I prayed with earnestness for the life of Tawney to be prolonged through Buchanan's administration. And by God, I'm a little afraid I've overdone the matter." So, well, the fact of the matter is that the United States courts were then, I think they probably still are today, the most powerful judiciary in the world. And during the Civil War, they could literally stop an army on the march by issuing a writ of habeas corpus. Now, let me explain what I mean by that with an example. The writ of habeas corpus had many uses in the 19th century, and not the ones necessarily that come first to mind today. If somebody wrongfully arrested, the judge checks upon it and lets him go. Well, during the Civil War, for example, the Army had many underage soldiers in it. You couldn't enlist without your parents' consent until you were 18 years old. But a lot of soldiers younger than that did enlist, volunteered, and they did it, their brother had joined up, and it seemed like a glorious and exciting thing to do. Or they had an abusive father on the farm, they couldn't wait to get away from him. Whatever the cause, there were many people who were under 18 who enlisted, who lied about their age, and who were accepted in the Army because, well, it was very difficult to prove age. There's no birth certificates. And so as a result of that, age was, if you challenged the age, it could only be proven by entries in the family Bible, say, or by testimony from grandparents. And family Bible entries can be forged. Grandparents might lie. And so it was very hard for the Army to prove the age of a soldier. So some youth imitating his brother would enlist underage, get in the Army, and find out it wasn't quite as glorious as it had seemed when his brother joined. He could get a lawyer. A lawyer could go to a judge and ask for a writ of habeas corpus. The judge would demand that the commander bring the soldier into his court and explain whether he was under age or not, as though the Army were a jail and the soldier had volunteered to, hadn't volunteered to be in it. It's not quite what it seems when we think of the habeas corpus in its common uses. So the Army fought these cases hard as they could. Their view was that once you were in the Army, there were only two ways out, and that was in a coffin or when the war was over. And the idea that the soldiers could sit around scheming to game the legal system somehow and get out, they thought that was entirely destructive of military discipline and dangerous to the organization of the Army. The Lincoln administration did as well, and they had a great deal of trouble with this because this powerful judiciary was on the whole politically hostile to the administration. The country's politics had been dominated by Democrats for the whole generation before the Civil War. And so judges with life tenure or with very long tenure the judiciary was just stacked with Democrats who would rule in habeas corpus cases to allow soldiers to escape the Army. In fact, one of Lincoln's proclamations suspending the writ of habeas corpus is specifically for these kinds of cases. So, it's important to realize then, remember, that the contest between the executive and the judiciary isn't as unequal as you might think. And furthermore, it's important to remember that cases involving the writ of habeas corpus don't necessarily have to do with political dissent or political criticism of the war. All right. Okay. Well, it's still the record of the Lincoln administration it leaves us with questions of civil liberties, more than 15,000 arrests of civilians in the North by military authority during the Civil War. And in order to judge the administration, we need comparisons and some kind of system. So I've been writing about civil liberties under the Lincoln administration for about 25 years. And so I've come up with a system for ranking presidents' policies on the civil liberty, for ranking their internal security measures. And in this way, we can kind of get a comparative grip on the question, I think. And so today, I want to deal with, let's see, there are four other presidents illustrated in there. John Adams, and Woodrow Wilson, and Franklin Delano Roosevelt, and George W. Bush. I'm going to deal with the first three. I write only about dead people. And so, I do have the system, and I must confess, I'm a college professor, and I just can't help it. Along with this system, I have a grading system, all right? And so it goes from F to A. So we're going to give grades to the presidents on their internal security system. And I think there are three ways of testing them that are essential. Three questions you have to ask of an internal security system imposed by an American president. And the first one is, does the system, is it proportionate to the threat, all right? Or is it out of all proportion to the threat? We've seen that the language that presidents use is often way out of proportion to the threat, right? But I'm talking about actual behavior, all right? Who gets arrested? How many? For what reasons? All right. The second question is this. Is the internal security system used for other purposes than meeting the original threat? That's a very important question. And there are lots of considerations under it. We have to pay particular attention to the use of an internal security system to prey on vulnerable portions of the society, and people who are identified for arrest, for example, by their ethnicity. The law professor Jeffrey Stone, who wrote a very good book on this called Law and Liberty, says that, quote, almost always the individuals whose rights are sacrificed are not those who make the laws, but minorities, dissenters, and non-citizens. In those circumstances, we are making a decision to sacrifice their rights. So, in that case, following what Stone says, we have to ask that question: is there collateral damage, or is this used for other ends? And the crucial part of this test for the 19th century was: is the system being used to eliminate the opposition party? That's the big question they asked then. And the third thing we have to consider is this. Once the initial threat ends, does the internal security system also end? Jeffrey Stone calls this a sunset provision. So if we look, for example, at the Alien and Sedition Acts of 1798, over which President John Adams, what he administered, they had what Stone calls a sunset provision. That is, they would no longer be, in fact, the sedition part of the Alien Sedition Acts would no longer be in effect when the next president came to office. So that was about a 2-year period. And when I read that in Stone's book, I hadn't thought about it, but I went back and looked at Lincoln's proclamation suspending the writ of habeas corpus, and I noticed that they applied during the existing insurrection. Those are the words in them. And alas, though, we don't really know for sure whether Lincoln would have relaxed it when the threat was over, because he died before the Civil War was completely ended. Now, as for the grading system, I allow a full range of grades from F to A. All right? That's what I give at Penn State, F to A. The Well, the F grade, what's that? I reserve that for anyone whose internal security system kept on being used after the threat until he became a dictator. All right? So if he became a dictator, you get an F. Well, obviously, you know enough American history to know that that didn't happen. And so I'm not going to give any Fs today. But otherwise, we have the full range of grades. All right? So let's begin with the first person in your handout, John Adams. I give him a D. And that's because of the Aliens and Sedition Acts of 1798. The main thing there is to remember that he fails the provocations test. There wasn't even a war. There was, when the Alien and Sedition Acts were put in place, only a quasi-war with France. This was fought on the seas only. As Jeffrey Stone points out, some 316 American ships were seized by the French, but it was all at sea. So the arrest of Baltimore newspaper editors and the other sorts of people who got arrested under the Sedition Act, that doesn't really have anything to do with ships on the seas. So Adams' system was principally had other uses. And here are the facts and figures. We have to look at behavior. Remember, not just what they say. Under the Sedition Act, 25 people were arrested, 14 indicted, and 10 were tried and convicted. So you say, well, gosh, that's not very many. All right, well, the trick is that almost all of them were Jeffersonian Republicans, and they were newspaper editors, printers, and public writers. If you look at what the media historian Michael Schudson says about this period, there were only about 200 newspapers in the whole country at the time. And of those, maybe 50 were Republican newspapers. So that means that the Adams administration took legal action against as much as half of the Republican press. And that a quarter to a third of all the Republican editors were indicted. Now, this is a full-scale assault on the opposition party, not on the French Navy. All right? And since a newspaper was the one essential thing that any political party had to have to exist, this was a very serious threat to having a political opposition. The Adams administration also, I think, flunks the victims test in the sense that the alien part of the Alien and Sedition Acts was aimed at vulnerable immigrants, principally. So the Adams administration, as it turns out, passes only the sunset test by Stone's definition, and otherwise it fails. How do we account for this? I think the answer is that it was, after all, an 18th century presidential administration, and it functioned in an era when there was no belief that there could be a loyal opposition, when there was a belief that political parties were essentially seditious. And so that, I think, helps explain the bad record of the Adams administration. Well, let's move up into a very different period and look at Woodrow Wilson. I give him a C-. He rates above Adams. I'm a notoriously tough grader, okay? So he rates that grade because Wilson, he gets a higher grade than Adams because Wilson certainly didn't altogether fail the provocations test. He has a real war and a big war, World War I, but it was a foreign war which offered very little threat to what we have come to call the homeland. The internal security system under the Wilson administration was aimed, at least in part, at sedition and espionage. It was much more extensive in its effects than the Adams administration program. Congress passed espionage acts in 1917 and 1918, and under those, and here are the facts and figures on behavior, they're critical. The administration conducted 2,168 trials and brought 1,055 convictions. Now, one of these, just yesterday, I visited the courtroom in which Rose Pastor Stokes in St. Paul, in what's now the Landmark Building, was convicted under the Espionage Act for, I think, writing a letter to the editor of the Minneapolis Star. It was serious. She was given a 10-year sentence. The decision was later overturned. But that gives you some idea of even the local impact of these measures. Besides these, it's clear that the Wilson administration used its internal security system to attack groups that it didn't like for other reasons. 150 leaders of the industrial workers of the world were arrested under the system. The administration also failed the victims test because it arrested 6,300 enemy aliens and incarcerated them. And the principal way in which they threatened liberty was to allow the quasi-governmental vigilante American Protective League to conduct what were called slacker raids. These resulted in the arrest of some 40,000 individuals. And these were essentially the American Protective League would sweep down on the cheap hotels in a city and just arrest any young man in there that was of draft age. And that resulted in 40,000 arrests. And some of these were, as I say, many of these were clearly aimed, had other purposes besides internal security. They were aimed at an opposition party, namely the American Socialist Party. The historian James Green argues in Grassroots Socialism, quote, wartime repression and patriotic coercion killed the Socialist Party in the Southwest. It's also true, I think, that the Wilson administration doesn't really entirely pass the sunset test, because the atmosphere of repression and continuing arrest by the Attorney General were parts of the anti-radical program after the war was over, the so-called Red Scare. So the system doesn't really end altogether. Okay, Franklin Delano Roosevelt. I give him a D. His saving grace, of course, came on the question of provocation. World War II, of course, included a Japanese attack on United States territory. And if you've read John Lewis Gaddis's very good book on this, called Surprise, Security, and the American Experience, and he points out that attack on the United States has been very rare, and surprise attacks on the United States even rarer. There was really only the British burning of the White House in 1814 in the War of 1812, and Pearl Harbor, December 7th, 1941, and then finally 9/11. And so one of these challenges Franklin Delano Roosevelt had to face. But the people actually targeted under Franklin Delano Roosevelt's internal security system, Japanese Americans, offered no real provocation themselves. I don't think there was a single act of sabotage or fifth column activity by any Japanese American in all of World War II. The provocation, moreover, had pretty clearly been removed even before Roosevelt imposed the system. At least the head of the FBI, J. Edgar Hoover, claimed it had. He said that he had already arrested all the people who were suspected of spying for Japan. He opposed the Roosevelt system. He said it was useless. He'd already done the job. So the Roosevelt administration pretty spectacularly fails the victims test, because the identification of the enemy in this instance was entirely by skin color, not by their likelihood to threaten national security. It's notorious, of course, that the Roosevelt administration did not put German Americans in concentration camps. It didn't put Italian Americans in concentration camps, as it did Japanese Americans. Now, I will say Roosevelt passes the Jeffrey Stone sunset test because he ordered an end to this system before the war was over. But I would say we could balance that on the other side by pointing out that the system had been planned before any provocation, well before the attack on Pearl Harbor. It had been planned by the Navy Department in 1936, 5 years before the attack on Pearl Harbor. They planned concentration camps for Japanese Americans then. The plan, of course, as it turns out, was carried out. 120,000 persons arrested and put in, they were called relocation centers during the war. They changed the name. Okay, what do we do about Abraham Lincoln? I think that these examples I've given provide pretty much a contrast with the measures of the Lincoln administration. President Lincoln admitted, even when he was defending his system, even when he was defending it in a letter as scorching as that Corning letter, he admitted that mistakes could be made, that, as he put it, quote, instances of arresting innocent persons might occur, as are always likely to occur in such cases, and then a clamor will be raised, he said, unquote. And so Lincoln may have presided over a mistake-prone system, but Roosevelt's system was all just a big mistake. It's a very different thing. Well, if we're thinking about, though, what grade to assign Abraham Lincoln, I'll tell you the history of grades that have been assigned to him. You may be surprised at this. He's often been given an F. In other words, he was called a dictator for his actions on civil liberties during the Civil War. For example, by the great literary critic Edmund Wilson. He compared, in a famous New Yorker article, he compared Lincoln to Bismarck and Lenin and said they were all dictators. The people who founded political science in America about a century ago, many of them thought that Lincoln was a dictator, including, for example, the two political scientists at Columbia University, William A. Dunning and John W. Burgess. They thought that Lincoln had dictatorial powers. I think that in modern times, in political science and elsewhere, this has pretty well subsided. Not many people do it. And most modern historians give Lincoln at least passing marks. And it's because of one simple observation, which was made by the historian Harold Hyman in 1977. And he pointed out, after what I think is, 70 years of pretty muddled thinking on this subject, he sort of cleared the air, and he said, quote, the most remarkable thing about the presidential election of 1864 is that it occurred. In other words, that's how you get dictators. You say, oh, we have too big a national emergency to have all this divisiveness and criticism in the midst of a war effort. We've got to postpone the election, and then you keep postponing, and then postponing. That's how you get dictators. Lincoln had nothing to do with such a scheme. So he clearly wasn't a dictator. He clearly doesn't get an F, but that leaves the whole scale above F. I think, of course, that we can't absolutely evaluate Lincoln on the Jeffrey Stone Sunset test because he was murdered before the provocation entirely ended. If you pay close attention, state by state, to the operation of the policies, and in particular, if you look at Missouri, which had the biggest problems in the North during the Civil War, it's pretty clear that near the end of the administration, Lincoln was relaxing martial law. And so there are some clues what direction he was going, but we don't know for sure. And as for collateral damage, I think, who were the victims? I think Lincoln has a pretty good record on that. But still in all, we are faced with that figure, 15,000, probably a lot more than that, civilians arrested by military authority during the Civil War with very limited sabotage and fifth column activity in the North during the Civil War. And so I think that actually what I'm going to do is end with a question and not an answer. What grade would you give Lincoln?
Take questions.
Thank you. I'd just like to go back to the Corning letter, and what surprises me is that Lincoln felt it necessary to make such a multi-pronged defense of what he had done, given that, it seems to me anyway, that Article 1 of the Constitution pretty clearly states that in the case of a rebellion or invasion, the president can suspend the
Okay,
writ of
very
habeas
good question.
corpus.
And it's really two questions in one. That is, well, couldn't he suspend the writ of habeas corpus anyway? And so why does he need such a vigorous and scary defense, right? Well, in fact, actually, what the Constitution says in Article 1, Section 9 is that the writ of habeas corpus shall not be suspended except in cases of rebellion or invasion when the public safety demands it. It doesn't say who. And it's in Article 1, which is the article of the Constitution dealing with Congress. So most authorities, most people in the Supreme Court, most people who had written about the American Constitution, they just assumed it was a congressional power. And so what was controversial about what Lincoln did is that the president suspended it, all right, in terms of the unconstitutionality of it. And Roger B. Taney challenged that immediately in a case called Ex parte Merriman and said the president didn't have the power. Now, then, how do you account for this hair-raising defense that Lincoln gives in June of 1863? And I think it is essential to understand, he learned about the arrest of Vallandigham from the newspapers. He took a very bad case here. But he was a good lawyer and could defend even a bad client. But why does he sound like that? And the explanation, this is the historian's explanation for everything, right, is context. This is what a historian does, a historian of the Constitution does that maybe a constitutional lawyer doesn't do. Whenever you look at a statement from the Lincoln administration during the Civil War, one thing you always want to say is, where was Robert E. Lee's army? Where was Robert E. Lee's army when the Corning letter, which was issued by the president on June 12, 1863, where was Robert E. Lee's army? He was on the brink of invading the North after the victory at the Battle of Chancellorsville, the campaign, of course, that would end in Gettysburg. So in other words, this is what a president says when the enemy is at the gates. It's essential in all statements on constitutional questions to contextualize them, and it's very important in the case of the Corning letter to do that.
Busy grading.
Yeah.
I have an easy question for you. Could you give us the on the Taney quotation in reference to Dred Scott? Could you give us the name of the book and the author again, please?
Oh, sure. I'm glad to do that because it's a great book. The author is Don E. Fehrenbacher, Fehrenbacher. As I say, there's a copy of this book in the bookstore here. He wrote a big kind of doorstop-sized book on the Dred Scott case, and it's called the title, there's a subtitle, but the title is The Dred Scott Case. But then, happily for us, he also later abridged it in a shorter version. So you can have the long version or the kind of Reader's Digest condensed version, but they're both very good. It's the definitive book on the Dred Scott case. And a model of clear writing. I don't know if you've read much Supreme Court history. It is not generally marked by clear writing. In that regard, that's another regard in which it's a very great book and has very incisive judgments on the nature of the court and the nature of the decision itself. and a very striking portrait of Roger B. Taney in the bargain.
Can you comment on Lincoln as a lawyer contributing to his exercise of the Constitution during the war?
Oh, yeah.
Or who her advisors were?
Sure. That's a great question. And there is, I think, today, considerable, a lot of people argue that Lincoln was a very successful lawyer, and in Illinois, a lawyer's lawyer. That is, he argued a lot of cases before the Illinois State Supreme Court. That meant that lawyers hired him to argue cases. There is a fairly substantial argument to be made that this was preparation for the great constitutional questions that Lincoln faced in the Civil War, and that law practice was a step to statesmanship. And I'll have to say that I simply do not think that's true. And I'll tell you why. If you look at Lincoln's constitutional ideas, I think he has three essential outlooks on the Constitution. One of them is nationalism, and the second one is broad construction, and the third one is he has essentially an anti-slavery interpretation of the Constitution. Now let's go back and think about that. He's a nationalist, right? Well, what made him a nationalist? How early did he become a nationalist? Well, from boyhood. Lincoln is born in 1809. That means he's 6 years old when the War of 1812 ends, right, in 1815. And one thing that everybody knew in the United States about the War of 1812 is that we damn near lost it. And that we better do something quick, that you don't have a country if you do not have roads to march your troops on, if you don't have infrastructure to support them, if you don't have banks that can dispatch their pay, you don't have a country. And so the United States embarked on a crash campaign to make this a country. And that's both in terms of ideas and patriotism, but also in terms of building roads and canals and having protective tariffs so that manufacturing can arise. And Lincoln grows up in this atmosphere that most historians call the era of nationalism in the United States. And so that's just part of his youth, that he becomes a nationalist. Well, Lincoln also, of course, the other thing that marked him in his youth was that he was a poor boy growing up on essentially subsistence farms in Kentucky and then Indiana. He grew up as an ambitious boy on a lazy frontier. Now, it's hard for us to think. We think of the frontier as being enterprising and all that. The frontier was lazy. And the reason, well, they had a good reason for it. And that was there was no way to get a surplus to the market, right? So if you're going to grow a surplus and it just rots in the field, what's the point, right? So if you were forced to be just a subsistence farmer, well, then what the farmers did was opt not to grow a surplus, they opted for leisure. Charles Greer Sellers, who wrote a good book about this called The Market Revolution, he points out, that they didn't call it leisure, they called it hunting and fishing. And I should also say that the women didn't opt for leisure, but it was a patriarchal arrangement. And so Lincoln looks around him, and his father looks lazy to him. All his stepbrothers are lazy. All the people seem lazy, but he has this ambition to get ahead. And there was no way to get ahead. He can't get a bank loan. There isn't even a proper road or railroad to get off the farm. And so, in other words, he looks around him, and this is existential for him, that the country become economically developed. And the political party that offered the platform of economic development was the Whig Party. And that's why Lincoln's a Whig. It's really existential with him. He likes the program of economic development of the Whigs. Now, they wanted national government support to build canals and roads and eventually railroads. And of course, the Constitution doesn't say Congress may build canals and railroads. And so if you go for a government program like this, as Lincoln did, you believe in broad construction. You have to. So that part of his constitutional ideas, that came from really his economic situation as a youth. And then finally, he had the anti-slavery outlook on the Constitution. And this, again, was from very early youth. Lincoln said that he thought he was naturally anti-slavery, that he could not remember when he did not so think and feel. So in other words, as far back as he could remember, he was anti-slavery. Now, the Constitution, I said the Constitution was a problem for emancipation, and the Constitution was a serious problem for the anti-slavery movement because slavery is mentioned 3 times in the Constitution, not by name, but 3 times in the 3/5 compromise on representation, and then in the fugitive slave law, and in the provision that said that the international slave trade couldn't be ended for 20 years for any state that wanted to retain it. And so, no cause in the United States wants to have the Constitution against it. This was a terrible problem for the anti-slavery movement. So what they came up with was an anti-slavery interpretation of the Constitution. They said, well, yes, there are these provisions in the Constitution that deal with slavery, but the founders very carefully never used the word slavery. And they used euphemisms for it, like persons held to service or labor. They said that instead of slave. They said what that means is that the founders were ashamed of slavery, that they looked forward to a time in the future when slavery would disappear, and so the Constitution was essentially a liberal document that looked forward to the end of slavery. That was Lincoln's view of the Constitution as well. Now, you take all 3 of those views together, they come from very early youth, and he could have had them all without ever setting foot in a courtroom. So the essential ideas don't come from the practice of the law. He did practice law, and he was a good lawyer, but that's not, I think, where the preparation for statesmanship comes.
I respect your ability to write only about dead people, but let me phrase the question differently. What grade would you give to the current Patriot Act and the uses to which it's been put?
Well, I'll have to say thank you for respecting my not wanting to talk about it. And I'll have to say I have not read the Patriot Act, and that's sort of I write on the 19th century, and I have plenty to read there. And so, what I know about the modern times is really not expertise. All right, I know what I read in the newspapers, and so my opinion on such matters is really like anybody else's opinion. And that's why really I shy away from saying it. If I had the time to deal with it seriously and had read the Patriot Act, which I think is pretty long, but if I had read the Patriot Act and had looked at these things past the Roosevelt administration seriously, I wouldn't be afraid to weigh in, but right now I just really can't do it. You want to know what grade I'd give Lincoln, though? None of you has said. B minus? Oh, yeah. Any others? A, C plus? Yeah, well, these are all, in my grading system, those are all good grades. But I'm a tough grader. Actually, B minus is closest to the grade I'd give. I give Lincoln a B plus. And certainly the provocations test he meets. And the victims test he doesn't have terribly serious problems with. Most of the problems are caused by the fact that it's a 19th century administration. And although he has clear ideas about who ought to be arrested and that the opposition party ought not to be a target of it, he doesn't really control all the people who make the arrests. So there are, it was an accident-prone system in this case. and that's problematic. And then, of course, we don't know for sure about whether he'd have ended it when it was over. We just can't know because he was murdered before that happened. But that's all. It's just the sort of scale of it that, in my mind, holds him back from getting an A.
You said that his reasoning came from Article 2, and he opines, or he asserts, that the ability to suspend habeas corpus, Lincoln being he, comes from Article 2, but that Article.
Well, that's right. Go ahead.
Article 1. Where did he get the idea that was where his executive authority came from, rather than it being a congressional authority to suspend the writ?
Right. Okay. No, the question is, well, if it was clear to everyone else that Article 1, Section 9, which is the part of the Constitution that says the writ of habeas corpus can, under certain conditions, be suspended, is the act governing Congress, why does Lincoln think the president can do it, and almost no one else did? Certainly no one else before the Civil War thought it did. And that's a great question, and we'd have to say first that we don't really know for sure. But then the circumstances were these. That is, Congress wasn't in session when Fort Sumter is fired on. And so Lincoln calls Congress into session to meet on July 4th, 1861, in an emergency section. But before that, there's still a lot of emergency to deal with. And so in that period, he suspended the writ of habeas corpus. I will say the idea that he was infatuated, that's one of the, whereas on the one hand I wanted to make clear how important the shaping of the Civil War was, how important the Constitution was in shaping and configuring the Civil War, and you have to look at the Article 2 for that. I don't want to leave the impression that Lincoln was infatuated with Article 2 and was, basically a hawk on presidential power. As far as we can tell, he wasn't. To the degree that he expanded presidential authority, it was for the moment, for the occasion. And I'll tell you a kind of proof of this. That is, when Lincoln had to give his first inaugural address in March of 1861, one of the things that he needs to do, one of the things I didn't say was there was one way in which the Constitution wasn't a big help, and that is secession. The Constitution doesn't say what Lincoln and most of the other people in the North wished it had said, that the Union was perpetual. It doesn't say that. The Articles of Confederation were called the Articles of Confederation and Perpetual Union. The Union is declared to be perpetual 3 times in the Articles of Confederation, but we chucked them. And so Lincoln, when he sits down and has to convince people that secession is not a good idea, he looks in the Constitution and, my God, it's not there. So he looks back on people who have faced similar crises before, and one of them, of course, is Andrew Jackson. And Jackson had faced nullification for South Carolina in 1832 and 1833, and had given a very forceful statement against nullification. And Lincoln, in preparing his inaugural address, used that. And he said, well, what did Jackson do? And among other things, Jackson had given a powerful historical argument to say that the Union essentially preceded the Constitution. All right? That was the argument, and Lincoln borrows it. Right? But he doesn't borrow all that Jackson used in the anti-nullification proclamation. Because among other things that Jackson argues, Jackson is famous, of course, for expanding presidential power, or for discovering presidential power, however you want to say it. But at any rate, he is the source of the powerful presidency in the United States. So when he faces nullification in 1833, and 32 and 33, he not only gives this historical argument, but he also says, the president is the only office elected by all of the people. So he is then, later people say that Jackson has the idea that he's the tribune of the people, and it's the only office in which all of the people place their will. Well, Lincoln doesn't borrow that. He's not interested in presidential power. He's interested in winning the Civil War. And so the expansions of presidential power are purely circumstantial, I would say.
I think we'll have our last question.
But suspension of the writ of habeas corpus essentially means you could arrest anybody without actually having a trial. So the Alien and Sedition Acts, you actually did have trials, and the Espionage Acts, you did have trials. So it seems to me that the suspension of the writ of habeas corpus is a bit more serious than just actually having criminal statutes about acts, okay? So, you got a response to that?
Well, I would say the suspending the writ of habeas corpus is very serious business. I didn't mean to imply otherwise. But I would say that, well, let's look at what the Supreme Court says. All right? What did the after we can see, for example, in the Stokes case, that her conviction is overturned, but after the war is over. So after the Civil War is over, the Supreme Court weighs in on the civil liberties question during the Civil War, but it's after the war is over. And so in the famous case Ex parte Milligan, the Supreme Court, which is full of Lincoln appointees now, the Supreme Court rules that it is illegal to have trials by a military commission when the civil courts are open. All right? And so trials by military commission, that was probably the most controversial part of the internal security measures of the Lincoln administration, is that these people, when they came to trial, if they came to trial, were sometimes tried by military commission. Vallandigham was tried by military commission, and that the Supreme Court didn't like. But they never ruled on suspending the writ of habeas corpus in wartime. And most of these, the actual fact is that most of the prisoners, what I did in The Fate of Liberty, that the first book I wrote about this is, well, at that time, I apologize to all judges and lawyers who are here. At that time, I was interested in prisoners who actually got arrested, and judges and lawyers bored me. And so I didn't really look at what they said, but I looked at what they did. And so when I studied the arrests, I mean, one of the things you can see is that people were arrested, they were detained for a little while, and then released, and usually didn't get to trial. And, people almost always say, well, in the cases where these people who were whose liberty was interfered with, if they were newspaper editors or something like that, didn't that have a chilling effect? And the astonishing thing is that it did not. Those newspaper editors in the 19th century, they were tough as nails. And I'm studying it right now, and there were numerous cases. These weren't really administration measures exactly. There were numerous cases in which the Democratic newspapers in the North, little towns all over, would be shut down, raided by soldiers who were home on leave and be angry about their policies. And they would trash the presses, trash the office, and without any arrest made afterwards by local Republican sheriffs or anything like that. So if you look at those and then look at what the newspaper does after this threat, to their liberty, they're just as critical and bitter as they were to begin with. No more bitter, no less. It seems to have had almost no effect on them. And so what that tells us about journalism and freedom of the press in this period is it really wasn't journalism. It was part of party politics. And so the press basically existed for a political party, and they did the work of political parties, the idea work they did, the propaganda work they did. And so being interfered with temporarily by another administration, that was just another day in the office.